Good evening, everyone, and thank you very much for being here tonight at this Law Department's public event on law and wealth. I'm Emmanuel Melisaris. I'm an associate professor here at LSE Law. I specialize in legal philosophy and criminal law, so a bit of law, not a great deal of wealth. Nevertheless, I'm going to be chairing this event tonight. I'll be your host. Before I introduce our guests, let me say a couple of things about the format of the event. The point of it is the first point is to showcase the fantastic cutting-edge research that is being carried out in the law department, focusing on the relationship between law and wealth. Precisely because that's the aim of it, we're not going to do it in the usual format of an opening statement of 10-15 minutes or whatever, and then question and answer. But the whole thing is going to be a Q&A session of sorts, which is why we call it a question of law and wealth. So I'll start by asking our panel one question or two each, and then 20-25 minutes in we'll open it to the floor. So let me introduce our panel. Starting from my left, from the far left, Jonathan Fisher, QC, is a visiting professor here at the LSE and has been a visiting professor for a while now, since 2006, I think, Jonathan. He teaches corporate crime and financial crime on the LLM program. He's a leading barrister in the areas of corporate crime, financial regulation, fraud, proceeds of crime, and tax evasion. He has been recommended, and this one is my favorite, in legal directories as calm, sure, and deadly at spotting the weaknesses of the opponent's case. So I suppose it's a good thing that you don't have any opponents here tonight. We're all on the same side. Jonathan is a co-author of the Law of Investor Protection, as well as many papers and articles. He's also the general editor of Lloyd's Law Reports, Financial Crime, and an editorial board member of Simon's Taxes, a fellow of the Chartered Institute of Taxation, an accredited trusts and estates practitioner, and an honorary steering committee member of the London Fraud Forum. He also served as commissioner on the Bill of Rights Commission between 2011 and 2012. Niamh Moloney is a professor here at LSE Law. She specializes in EU financial market regulation and in fact wrote the first monograph on the topic. Invented the subdiscipline, I suppose, not just specializes in it. The monograph is EU Securities and Financial Markets Regulation. It's now in its third edition since 2014. Niamh is a member of the Advisory Securities and Markets Stakeholder Group of the European Securities and Markets Authority, which is a bit of a mouthful. And other external appointments include being a member of the Consumer Advisory Group of the Central Bank of Ireland and being a special advisor to the major 2014-2015 inquiry by the House of Lords EU Select Committee into the EU's regulatory response to the financial crisis, which committee reported in February 2015, and the title of the report is The Post-Crisis EU Financial Regulatory Framework, Do the Pieces Fit? So it was in pieces, yes. Dr. Eva Michler is a reader in law at the LSE and an Universitätsprofessor at the University of Economics in Vienna, where she took her habilitation in 2003. Before joining LSE, she was also a TMR Fellow at the Faculty of Law at the University of Oxford. One of Eva's research interests is in the law of investment securities in England, Germany, Austria, and Russia, and indeed she has done quite a lot of comparative work on the law of securities. Another focus of her research is the law of corporate finance, and in particular the law of equity finance. She has worked and published on, as I said, comparative Austrian, English, and German company law, and on the company laws of the emerging economies in Central and Eastern Europe, in particular Russia. She is the author, amongst many other things, of Property and Securities, published by Cambridge University Press in 2007, and Wertpapierrecht zwischen Schuld- und Sachenrecht, published by Springer in 2004. Joe Spooner joined the LSE as an assistant professor of insolvency law in 2013. Before that, he was based up the road at University College London, where he did his doctoral research on personal insolvency and worked as a teaching fellow in conflict of laws. Joe has also worked at the Law Reform Commission of Ireland as principal legal researcher on the Commission's consultation paper, interim report, and final report on personal debt management and debt enforcement. These publications influenced the enactment of the Personal Insolvency Act 2012. As you might have gathered, Joe's primary field of research is the law relating to consumer household indebtedness, with a particular focus on personal insolvency law. He's also a member of the World Bank Task Force on Insolvency and Creditor-Debtor Regimes, and a contributor to the report on the treatment of the insolvency of natural persons. So these are fantastic guests. Now a couple of things about our topic. As I said, it's about law and wealth. So the big question that we want to address is how the law facilitates the production and distribution and accumulation of wealth. And we're going to do that from within the areas of expertise of each of our guests tonight, of the members of the panel. There are some second-order questions that we can ask, some big questions. So how do legal instruments organize the mode of production and accumulation and distribution of wealth? Is law secondary to the market? Is it always subordinate to market imperatives? So does it just formalize market imperatives? Are there any specifically legal ways of impacting on markets? So does it work the other way around? Is there anything about the form of law that may perhaps address injustices or inequalities caused by the market? Is there and can there be uniformity across different fields of law in the way that wealth is being produced and distributed? So these are, I think, some of the second order questions, but as I said, we'll start from the specific and in due course move on to the general. So I'll start with Niamh and ask her to tell us a few things about her work on household investors, involvement of the small guys in the financial markets.
Yeah, so thanks very much, Manola. So I work, I suppose in some respects, in the more kind of rarefied aspect of all of this, because I look at the retail investor. Now, one of the things I try and pull out is, well, what is that person for a start? What are they empirically? What are they legally? What are they as a matter of policy? But I think we all have an instinctive sense. A retail investor has a little bit of cash. Yeah, there's discretionary income there in some respect, whereas I think Joe would be focused on a different group of people. So we have people with a degree of discretionary income, and how does the law sort of interact with that? Now, the kind of core question I would ask is, what is the job of law? Now, law can really do two things, I think. One is it can market markets, come in, the water's fine, investor shares, make money. So it has a sort of a marketing dimension. Or the other thing it can do is it can be much more paternalistic, much more protective. If you go in here, go in with the following warnings, the following controls, and so on. And I mean, what you see, Manola, is over the last years, before the financial crisis, law very much in the marketing camp. So law constructed the retail investor as this Olympian, empowered financial citizen. So someone who had a duty almost to take their savings and invest in the markets. Now, why? If we go to the notion of wealth, your savings get transferred into the real economy, you're supplying capital, you're supporting the economy. And secondly, you're taking the pressure off government. You're taking on welfare support. You are saving for education, you're saving for health and all the rest of it. Now, how does law start interacting there? We see things like proportionality. We don't want excessive rules. We see things like disclosure. Information is important. We see things like choice and innovation. Make it easy for the markets to produce lots and lots of products. Make it easy for banks to find consumers. So very much a strong dimension of that. But one of the things I see in my research is that's very tied to the economic cycle. So the point at which wealth is being generated, the point at which it is in the cycle. And all of this came to kind of a juddering halt, of course, around about October 2008. And one thing I was interested in at the time was financial literacy. So how can we construct a legal system that is based on rationality, more or less, where a lot of the evidence tells us people can't contract. They find it very difficult to make choices. Maybe they shouldn't be allowed to go into the markets. And interestingly, when the crisis broke out in September, October, November 2008, nothing. You have a deafening silence across every single investor education website on every single regulator globally. Now, there might have been one or two exceptions. Nobody is saying, calm down, don't panic. Sell, don't sell. Nothing. So there's a whole kind of cyclical behavior here. And right now, something I'm looking at in my research is how that's changing. So we focus less now on wealth generation. We focus now on the investor as a consumer, and a consumer of highly dangerous products. They're like consumers of medicines, of electrical products that might explode in your face. So we're seeing these big kind of cyclical movements in how the law constructs this person who's engaging with the markets. So a lot of what I try and do is figure out, well, is there any truth in either of these positions? Should one or other win? And if so, what's the role of law in all of this? But one of the challenges you have as an academic lawyer is kind of tracking and shifting these big movements, which are very tied to the economic cycle.
Thank you, Dave. I find the idea of financial citizenship I find absolutely fascinating, actually, because it sort of marks an inversion of the idea of citizenship that we generally have. It's citizenship through the market and through the private domain. I'm having read some of your work as well. I also find it quite interesting how various instruments try to protect small investors. It's always at the point of entry.
Yes.
That's where protection is being offered. Minimizing risk at that point, so leveling the playing field by making it compulsory for investors to take advice and that sort of thing, which we may come back to that, but I suspect that it might cause all sorts of other problems. So maybe a parasitic market of advice.
Absolutely.
Maybe,
absolutely. And one of the effects is you're generating a very strong moral hazard or a signaling dynamic. You must get investment advice. Well, if the law is requiring investment advice, that has to be something really special. I can rely on my investment advisor kind of switching off again, rational capacity. Another dimension to this is you can take it to a further extreme. At the point of access, Manolis, before you buy a share, should we require you to, in effect, have a driving license, a share license? Do you really take over capacity by licensing the investor, not necessarily the market? So,
quite. Aoife, you've done a lot of work on the complexity of financial markets.
Yes. So, and I would like to pick up on what Niamh said about investment products being dangerous products, a bit like explosives that can explode in your hand or in your portfolio. And so what she's looking at is the dangers that lurk from the quality of the issuer. So is what you're buying, is the money you're lending to a company in whatever form, that may be in form, you're giving money to the company in the form of becoming an owner of that company, and that's a form of lending, because the company then uses the money to develop products or invest in its business, or you can do it in the form of debt. So what Niamh is looking at is the danger that lurks at the level of that issuer. And what I look at is the infrastructure between you as an investor and the issuer. And what you see there is that this infrastructure is incredibly complex. So when you buy a share, very, very rarely do you have a situation where an individual, like yourself, would buy a share and have their name on the register of the issuer. Very rarely do you have a direct relationship. Very often there's funds, there's a fund in between, sometimes there's a fund of a fund, And more often than not, there's not only funds, but there are also custodians. And very often there's not just one custodian, but a whole chain of them. So what has happened, this is a fairly recent development, and you could say 25 years ago, investments were held a lot more directly than they are held now. What has happened is you have a culture of outsourcing. So the people you make a contract with reserve in that contract the right to employ other people that they will give your money to, and they will look after that money, or they will look after the investment you have bought. And so a complex web of intermediaries has developed that the holding of assets has been delegated to. And this results in a situation where it is very difficult to track down the assets you own. So there have been cases in London where investors have tried to sue issuers and couldn't, because they couldn't prove that they were owners. Because the issuer said, yes, you have a statement that says you hold those securities, but we don't know you. We only know the custodian who is on our books, and we know it's not you. And then it's very difficult to pierce through those layers and layers of intermediaries. And another example is when Bear Stearns, that was an American bank, went bust in 2008. They came up with a plan to restructure it, and they bought out the shareholders. And they found that there were 28% more shareholders than the bank had issued shares. So what had happened was the communication between the intermediaries in that structure was so poor that there were 128 people who thought they were shareholders, when in fact only 100 shares were issued. And then, in addition to taking the loss of the bank having the value, the asset itself, that dangerous product, being worth less than it was, there was a loss that these investors took solely because of the structure through which these investments were held. So JP Morgan then bought all of those 128 shares. But that means, of course, that every single one of those owners took a cut or a loss to the extent that the infrastructure absorbed the assets. And that is, and this is, it's slightly ironic because the problem arose with computerization. So before we had computers and electronic registers, people held shares more frequently directly. And computerization has made it very easy to delegate because you can communicate quickly, and that has meant that a very complex structure has arisen that has somehow disconnected investors from issuers. And that's in a small nutshell what I work on.
Okay. And I mean, apart from computerization, I can see how that may have made things faster, therefore more complex. Is one of the problems, to return to the law, the fact that it's all mainly governed by the law of contracts?
Yes, so it's governed by the law of contract, but it's really difficult to do something about it through the law. Because you don't want a situation where, like, regulation is reactive, so you can tell custodians you must look after other people's assets, but if they don't do it, there's nothing much you can do. And if you start imposing mandatory law, well, there's no limits to the creativity of contract lawyers to write agreements around that. So it's incredibly difficult for the law to sort of pin down an evolving market. And I think that maybe, you're the legal philosopher, maybe a problem of the sort of reactive nature of the law.
Right. If you're expecting legal philosophers to solve the problem, then you'll have to wait for a very long time, I'm afraid. Give us 100 years or so. Thank you very much, Aoife. Joe, you're looking at asymmetries or inequalities between debtors and creditors at the other end. Right? So from the perspective of insolvency law?
Exactly, sure. So some of the issues that I discussed in my research would follow on quite closely from what we've discussed so far. I guess there are two major differences I would point to from the beginning. I guess I'm interested in questions of law and lack of wealth. So I'm interested in the indebted population, household indebtedness, and the 25% of our population who would have negative net wealth. And a second major difference, I guess, is looking at things from the insolvency or bankruptcy perspective. Manolis, you mentioned point of entry protection for consumers entering investment markets. Well, I look more, I guess, at the ex-post position. So what happens once consumers have entered into markets, they've borrowed money and things have gone wrong and they've ended up in a position of over-indebtedness or insolvency. So I guess those are two points of difference. But yes, very much in that context, I focus on the asymmetries we have between debtor and creditor, and this is a relationship almost defined by asymmetries. We can look at information asymmetries. We've talked already a little bit about complexity of financial products, and that's very much a live issue in the credit markets when we have household debtors who are borrowing from banks in relation to often complex loan agreements, often some sorts of terms which will not be entirely understood, and there is a sort of a trickle up wealth effect going on in that kind of scenario. We also have behavioral imbalances. I mean, Niamh has mentioned financial literacy. That's something at stake, and on the one side of the contract we have almost the ideal type of a rational actor, which would be the large financial institution, and then the other side of the contract we have a household debtor who we know will not necessarily always make decisions on a rational basis. So we have some problems there, some contracting failures, and these can produce failures in the market, and these can lead to certain social costs. And it's interesting here in terms of social costs, we see that debt contracts are not only born of asymmetry, but they tend to perpetuate asymmetry and inequality and develop new inequalities. If we take some of the literature that's been written about the Great Recession, interestingly, some people are now coming up with explanations of the Great Recession which look less to the initial financial crisis, and they look to what happened afterwards, and they see a crisis of consumer spending. Part of this is based on how debt contracts distributed the initial losses from the financial crisis. So if we have a debt contract, we can think of it as essentially a prediction about the future which both parties are making. Both borrower and lender expect that there will be repayment on certain terms. But if things go wrong and if economic circumstances change, the law through debt contracts has the effect of distributing all of these losses onto the debtor. So the debtor will still have to make 100% payment even if circumstances change. The creditor will have 100% claim. If we're talking about a secured contract such as a mortgage, a creditor will have 100% claim for the money owed and be able to enforce the security. And this can produce negative effects not just for debtors but for the wider economy as well, because if we're talking about losses being imposed on ordinary households who are parties who are not very well equipped to deal with these losses, these can have dramatic effects in creating a debt overhang problem. So this is to do with the idea, like if Bill Gates loses £50,000 off the value of his house, he probably doesn't change his day-to-day expenditure, whereas if an average family does, they're going to cut back a lot on spending, and if we multiply that across the economy, well, the economy can really slow down. So this, the inequality produced through debt contracts can have negative effects for all of us and not just for people in debt. And then this is where bankruptcy law comes in. So bankruptcy law has the ability to actually exhibit quite a lot of redistributive potential here. Bankruptcy laws allow households to obtain debt relief, allow them to restructure their debts or discharge their debts. And this is one means of providing households with a fresh start and restoring them to, I guess, economic and social inclusion. And this should be good, not just for these people, but on a wider level as well. So, I guess that's some of the issues that I'm looking at. And just when I was listening to Eva and Niamh, there were parallels in some of the issues they're talking to. And one of them, I guess, is this big debate about whether we should be facilitating access to financial products or whether we should be protecting people from them. And I guess these issues are raised at the ex-post level in insolvency as well. The impact of providing debt relief to households, well, does that mean that this will reduce access in the long run if debtors are able to be discharged from their debts, does that make lenders less inclined to lend? These kind of debates are quite live in this area.
Mm-hmm. Thank you, Joe, very much. I'm sure we'll come back to the public-private debt relationship very soon, because it is very interesting. I mean, after all, debt seems to be the main way in which wealth is being redistributed these days. But for now, I'll move on to Jonathan. The criminal law is not the most obvious way of regulating markets. So, people who are not familiar in how the law works wouldn't really think of the criminal law as being one of them. But it clearly does. So, how does it work, Jonathan?
Yes. Well, thank you. I mean, maybe it should be the obvious way people would think. Certainly, I'm concerned and interested in the way in which the criminal law engages the management of wealth. Not only in terms of its reactive role as the punisher of wrongdoing, and also, of course, the protector of property rights, but also as an activator in the prevention of financial crime. And so what I'd like to do is just give you an example to come down to brass tacks and tell you a little bit about what's really going on and seeing how the criminal law ought to be playing a role if it's not. So 3 months ago, back in November, the FCA fined Barclays Bank £72 million because they'd failed to minimise the risk that it could be used for the facilitating financial crime, in short, money laundering. And the failings related to a £1.88 billion transaction that Barclays had executed in 2011 and 2012 for a number of ultra-high net worth clients. Now, the clients involved were politically exposed persons. And there's no question that they should have been subjected to enhanced levels of due diligence and ongoing monitoring by the bank. In fact, as it happens, Barclays applied a lower level of due diligence than its own policies required for other business relationships of a lower risk profile. And Barclays subverted its standard procedures, preferring instead to take on these exposed people as quickly as possible, and they generated for themselves a very tidy little sum, £52.3 million. And Barclays went to unacceptable lengths to accommodate these clients. This is the FCA's words. Specifically, Barclays didn't obtain due diligence information which was necessary to comply with financial crime requirements. Barclays agreed to keep the details of all of this confidential, and their due diligence records weren't even kept on Barclays' electronic system. The FCA specifically found that Barclays' senior management had failed to oversee adequately Barclays' handling of the financial crime risks associated with the business relationship. Now, these facts demonstrate, I would suggest, that one of the UK's leading banks was prepared to ignore the risk of facilitating financial crime, motivated, I would suggest, by unadulterated corporate greed and a malign attitude towards adherence to regulatory standards. In this instance, what we're talking about is a breach of the money laundering regulations of 2007. So I ask a question, and that is as follows. When we talk about the criminal law, where is it? Why was Barclays Bank not prosecuted for a criminal offence involving breach of the money laundering regulations? I do not believe there has been one single prosecution under these regulations undertaken by the FSA or its successor body, the FCA. In the handling of individual wealth and collective wealth of our nation, our banks never seem to learn. This is the same Barclays Bank, I would remind you, that the FSA fined £59.5 million in June of 2012 for its failings in its handling of the LIBOR and Euribor markets between 2005 and 2008. And it's the very same Barclays Bank which the FCA fined £284 million in June of 2015 for failings in relation to the Forex market between 2008 and 2013. So where is criminal enforcement? What is the role of the criminal law in the management of wealth? More specifically, I would ask this in relation to the UK's leading companies. Is there a role for the criminal law in supporting a framework directed at the prevention of financial crime by encouraging better standards of corporate governance? And if so, can we develop a challenge for us? Can we develop a coherent narrative in which improved adherence to legal and regulatory standards is not simply coerced by the criminal law, but also acknowledged by companies and their directors as an imperative to conduct business in an ethical fashion, so that the corporation would no longer be considered as causative of this problem, but actually rather the key stakeholder in its solution. That, I would suggest, is an appropriate role for the criminal law.
Thank you, Jonathan. Do you think that the criminal law is, well, as it stands, on the whole, I mean, of course, there are different instruments of criminal law that regulate corporations, but is it fit for purpose? I mean, you know, one of the big questions in criminal corporate liability is how to strike the right balance between the incentive to do the right thing and the disincentive to do business at all.
Yes.
So, do you, for example, I mean, 72 million.
Yeah, well, it's peanuts. Look, so far as individuals are concerned, I rather think the criminal law in England and Wales is actually perfectly adequate. What we need to do is enforce it. As far as corporate criminal liability is concerned, I rather think in England and Wales it is lamentably deficient. And I think we need to do something about it. And it's not fit for purpose.
Okay, thank you. Right, I think we're ready to take your questions. I should have mentioned at the beginning that the event is being recorded, and hopefully a podcast will become available over the next couple of days. So if you want to ask a question, be aware that you're going to be recorded. And it is for that purpose that I'd ask you to wait for the microphone as well. So we'll take 2 or 3 questions to start with. One will make me happy? Yes, Matthias. And if you could please identify yourselves, and if you want to address your question to one of a specific member of the panel, please do so.
Thank you. Matthias Goldman from Frankfurt University. I've got a question for no member in particular, for any member of the panel who wants to pick it up. And that question is, if you talk about law and wealth, is there any inherent direction in the law that concerns the distribution of wealth? My impression sometimes is that there is a certain conservatism inherent in the law, because law secures rights, and rights are easily to be enforced and to be secured by the law. So isn't it that the law somehow is something that is not really conducive to any kind of redistribution of wealth in society, and that this requires rather policies which are always more difficult to come about?
Do you have another question for now, or shall we start with Matthias's very narrow question on the very nature of law? Yes, Philip, please.
Philip Pech from the Law Department. If I may come in on this one as well, asking a question in the same direction, there might be, and I see, a certain softness of the law, so that societies and actually the law itself play with itself some regulatory arbitrage, meaning that when it serves society, or what is perceived as serving the society at that moment, that this is what is decided by legislators, regulators, and maybe even the judiciary in that moment. So, building on what was just said, there might, for example, be a certain upstream redistribution that we can see, because the policy that is perceived as the good policy to bring nations forward, to bring economies forward, is often supposed to be keep those people and those businesses that are running the economy kind of in good shape. And I think one must maybe ask the question whether there can be objectively the right rule and the good law regarding the distribution of wealth, because there will always be interests. on different sides of the spectrum.
Okay. Well, this is related to Matthias's question. So the question is whether the law only as we said earlier, whether it formalizes extra legal imperatives, whether the rule of law is there just to ossify things that happen elsewhere, whether there is something specific to the law that might facilitate the pursuit of justice rather than the concentration of wealth. So, who would like to have a go first?
Well, I'd like to say that from the perspective of the area I look at, definitely the law serves those who have the greatest bargaining power and are able to design contracts that protect their position. So you find yourself in a situation where, as an investor, you're faced with some general terms that you can not negotiate on. And when you look at, so when you speak to institutional investors, I found, like talking to people from very large institutions, they're sometimes surprised that they've got the ability to negotiate terms because they're a very big player and they say, I've got this big problem and we don't know what to do. And the answer is, well, don't accept the terms, which as a big player you can do. And then, of course, within their organization, that is not an easy thing to do because the person you talk to is not on the legal team, and then this becomes a much more complex thing to do within an organization. But generally, I do believe that the law serves the wealthy better than the poor. And that is for designing contracts, but also I think for law enforcement. If you've got more money, you pay a better legal team, and that helps in litigation. And that's not particularly deep philosophical point, but I think something that is unfortunately true, and there's not much the law can do about it, I don't think.
Yeah, I think these are great questions. From sort of a regulatory perspective, which is where I come at a lot of this, I think law is inevitably catching up, but when it's catching up, it tends to be reinforcing a status quo. And I would say a lot of the time what it's doing is encouraging almost a recycling of wealth or a recycling of debt, certainly over the last number of years, because one of the things regulatory law, even in the retail space, really dislikes disrupting is market dynamics. It gets very nervous about sort of interfering with what it sees as the dynamics of the market. So doesn't like blocking innovation, doesn't like interfering with healthy dynamics, diversifying risk, spreading it out over the market. So it doesn't like kind of disrupting that. So if you look at the last number of years, so we've had the financial crisis, we've had the cost of bank rescue, effectively going to the taxpayer in an awful lot of places. So that burden, austerity, is being carried by the taxpayer. But then you look at sovereign debt, the actual debt instrument, and that's being used by states. That's been held by banks, it's been put into investment funds, and these are ultimately all flowing back, to the household investor. So another example might be one of the consequences of the crisis has been requiring banks to be able to bail themselves out, in effect, that you have more equity type securities that are the first to take a hit if a bank is in difficulty. So banks are now constructing different kinds of instruments which in effect will be the first to take a loss, if a bank is going insolvent. And regulators had to step in and issue warnings that those kinds of securities shouldn't be sold to households because they're taking on a huge degree of risk. But there's no law against that, or not fully. So it tends to reinforce the status quo, and it's partly because of this nervousness of disrupting what are seen as sort of almost, unavoidable dynamics in marketplaces. So I think it rarely distributes wealth to a greater extent than the market already is doing. It's reinforcing those dynamics.
I didn't cough suggestively. I wasn't asking you to stop. I really did cough. Jonathan, would you like to comment on this?
Yes, I can just say a few words. Obviously, from the perspective of a criminal lawyer, it's really an unexceptional proposition, is it not, that the criminal law, certainly when one looks at acquisitive crime, is there to protect property rights. That's what it's doing. It's restoring property to those from whom it was criminally taken. So in that sense, it's just not an exceptional matter. I agree with Nico. I mean, I'm sure that law is essentially a reactive discipline. We could have a wider discussion about what we think the purpose of law is. Do we think that it has some sort of redistributive aspect to its purpose? And I rather think people's views might be divided on that, and to some extent that reflects a division of view in terms of even a political ideology of what you think the role of the law is. Does it have some sort of redemptive quality? I'm not, as a criminal lawyer, I wouldn't go there. I think what I would say is this, that insofar as I might be arguing a case for saying that we should use the law, deploy the criminal law, to improve corporate social responsibility, in effect, is what I'm suggesting. I'm not really saying that because I'm driven by the redistributive process of the law. Any form of political ideology. It just seems to me that in terms of decent ethical values or some sort of moral value, we ought to be behaving decently, and that applies to companies as well as individuals. And I would stop there. No, yes, I would see law very much as quite narrowly with regard to the two questions that have been asked.
Thank you.
Yeah, well, I think I'm probably in agreement with the leaning of Matthias. I guess partly because Niamh has discussed some of the regulatory aspects, I think I would focus probably on court decisions in applying insolvency law or bankruptcy law in answering this question. And yeah, I do think that we can see a certain reluctance or trepidation to embrace the redistributive functions of insolvency law. So there's two ways that insolvency law have traditionally been thought about. One is that it's basically protecting and reinforcing market allocations and protecting the rights of creditors. The other view is the more progressive ideas, I guess I mentioned at the start of our talk today, emphasizing the debt relief function of the law. Now, because the majority of debtors who are using the law nowadays don't have any assets or income to distribute back to creditors, the debt collection or creditor protection angle of the law has kind of fallen away and withered a little bit, and policymakers have now more and more recognize that actually there are gains if we focus on this debt relief aim of the law and treat the law almost as a form of social insurance, whereby we are providing debt relief to the minority of debtors who have run into over-indebtedness, and that should be paid by all of us. If we pay a little bit more in our borrowing costs, it's like purchasing insurance in the eventuality that we run into over-indebtedness later in life. But in some recent Superior Court decisions in this jurisdiction, which I've looked at, dealing with some of the consequences of the recession, so dealing with issues like rent arrears, housing debt that has arisen, and even arrears arising in relation to the social welfare system, so social welfare benefits, I see that the courts are still holding on quite firmly to this original idea of insolvency about primarily protecting creditors, and seem reluctant to embrace the redistributive potential, and sometimes talking quite openly about their concerns they have about that, and talking about ideas like, well, it wouldn't be justified if the debtor availing of bankruptcy was put in a better position than every other debtor who's out there struggling to make ends meet and not entering into bankruptcy. But it's quite an extraordinary statement, really, if we think about it, because why do we have the law at all if someone's not better off from using it than not using it? So yeah, I think I would say that I identify a certain leaning in the law, and more comfortable with the protection of market allocated rights than with trying to upset those allocations.
Mm-hmm. Okay. Yes. Mm-hmm.
Yeah, this is a question about financial regulation. Sorry, I should say. I'm Andrew Dyson from the Law Department as well. So perhaps aimed mainly at Eva and Niamh, in particular following up from what Eva was saying about the importance of inequality of bargaining power and standard form contracts in these financial investments. Something I've been working on recently, something called contractual estoppel clauses, which is a relatively recent innovation in many standard form financial investment contracts, where the more powerful party, the advising bank, inserts a clause saying something like, the parties agree that we're not providing any advice, or you haven't received any advice, even though both parties know that that's exactly the nature of the contract. And the courts have upheld these clauses, so to deny the investor a claim in relation to negligent advice provided by the bank. So that seems one concrete, quite recent example where the courts have actually played a role in, if you like, entrenching the effects of this inequality of bargaining power. A more general point arising from that is that actually, I don't know what your views are on this, but Gerard McNeil at the University of Manchester has recently written a paper on contractual estoppel, where he argues really that everything went wrong at the time of the Big Bang in the 1980s, when going back that far, arguing that essentially once banks were able to act for both sides, there was at that time a kind of quid pro quo that this relaxation of the regulation allowing banks to work for both sides was to be accompanied by more specific protections in relation to inequality of bargaining power and negotiation of individual contracts. But insofar as that protection is now falling away, then that he's arguing that we're really in the worst of both worlds there. So I wondered what your views were on that.
We've got another question. The gentleman in the grey top and the glasses there. You can tweet your questions as well, if you like, and Bradley will pick them up and he'll let us know. If you're too shy to ask them here, so please. Yeah.
Thank you. My name is Michael Sleeve. I'm from the LSE doing a master's here. I had a question about not so much private wealth but public wealth, and I wondered what the panel thought about the Chancellor's idea to use primary legislation to introduce a budget surplus law that would bind future governments to maintain a budget surplus when the economy is growing.
Okay, thank you.
I'll give it a go. I very kind of carefully tread on contract ground, so I'll, the health warning as a regulatory lawyer. So yeah, that's a really interesting point, Andy, and it just puts a cart and horse through the whole kind of purpose of regulation intervening and completing a contract that otherwise, just is completely unequal. And the whole purpose of financial regulation is to deal with that huge imbalance of bargaining power. It will step in and cut through that. I think one of the answers to that difficulty, without knowing the case law, is there will be points where it is mandatory to take investment advice. That just has to happen. And if the investment bank or firm hasn't engaged in that, that's a breach of the regulatory area. Linked to that, of course, is the difficulty about access to advice. And if you're going to make advice the gateway into the markets, make it mandatory, make it compulsory, well, the first thing you'll do is create a very strong business incentive to get out of that market, because you're being exposed to all sorts of risks in terms of having to deal with retail investors. So it's a really difficult issue, and that's something the FCA is grappling with at the moment. In terms of Gerard's argument about principal agents, I guess everybody's seen The Big Short. Now, well, I really encourage you to go see it. So it's a fabulous, I think it's a great movie about sort of what happened over the financial crisis. And it exposes, we all, academics certainly, the notion of a principal agent conflict is riven in financial markets. But this film they're just everywhere. So absolutely. But that's the fundamental question. And if you can figure out how to fix those principal agent conflicts, you're home. I mean, once you've got that done, then you can default back to principles, you can default back to enforcing rather than more and more granular rulemaking. So I think he's absolutely right. In a multifunction world where you have products being created and distributed and sold, you're setting up these conflicts all over the place. I think one of the heartening signs of modern financial regulations in the last sort of 5 or 6 years is recognizing you have to attack the principal agent problem at all sorts of levels. So traditionally, the access point for regulation has been distribution. So the agent, the agent for another part of the bank, or the agent for the collective investment scheme, or whoever, talking to the investor. It hasn't worked. It's too hard to do. The incentives are too deep. So it's now going upstream to the very top. Well, let's look at the product that's going into the system and try and get at the principal agent difficulties there. So at least there's a sort of a diversification of the risk, if you like, in terms of regulation going wrong. But I think he's absolutely right. And then, Michael, going to your point about binding in a budget surplus, I think I sort of argue by analogy. I think it's a really powerful point. I think it's political. It's whether or not you can get a mandate to do that. That's a question for the democratic process. But arguing by analogy, that's what's happening post-financial crisis. The whole notion of a capital buffer, counter-cyclical design of regulation. I mean, we were hoping that's the brave new model that will give the financial system some resilience. So I think there's a very strong logic to that. But I think ultimately that's going to come back to, can you get that kind of mandate? But I think the functional logic is very powerful of that kind of decision.
Nothing to add.
The contract point. So let me say a bit more about how contracts work in these chain environments. What you have is, on the one hand, you have a list of things that your custodian is going to do for you, and they sort of say in fairly vague terms what their services are. And then somewhere towards the end of the contract, you have a clause that says, and we're also able to delegate the custody of your assets. And then something that says, at terms that we think fit. And what that really means is, forget about our promises at the beginning. Your rights will be determined by the terms that will be set when we delegate to somebody else. And not only that somebody else can delegate further. So they're not excluding anything, but they're just saying so we will outsource, and therefore the other terms apply to you. And this is very difficult for contract law to deal with, because what you should really say is that the terms in our agreement with the custodian inform the service levels the service quality at all other levels. But you can't do that because the sub-custodians, the subcontractors, are not party to that contract. And while you could say the contractual estoppel cases, you could say the courts can take a view interpreting regulation that they are invalid. What you need to jump over in the case of outsourcing arrangements is privity of contract. So you need to tell a sub-custodian, by the way, there is an arrangement further up the chain that binds you, and that's impossible. And it's impossible in England, of all jurisdictions, where contracts are literally understood, where courts are very, very careful about sort of making assumptions of what parties really thought. But imposing someone else's terms into a different contract, I can think of no legal system that would be comfortable doing that. So it's a very, very difficult, it's a combination of bilateralism in contract law, or like the privity of contract problem, and outsourcing. And once the two meet, rights seem to go through the roof, or rather seem to fall down a cliff, rather. And it's a fascinating mechanism, and it's really hard to see what can be done about it from a contract perspective. And from a regulatory perspective, because they span over jurisdictions, very difficult.
Yeah, well, you said earlier you don't think there's any legal solution. It's
more
of a structural solution that has to be found.
Yeah, well, so my idea, what you could do is of course you could look at things like blockchain technology and find a system where you connect investors and issuers directly. Which, I'm doing research into that at the moment. But I think contract law is just, with every best intention, the courts, they cannot impose different terms into a contractual arrangement. And the regulators can't do it either, really. They can just say, be sure you outsource responsibly.
Yeah, I'll just come in very quickly on the point about the budget surplus rule, and all I would say about that is that we should just remember there is a relationship between public debt and private debt, and that one of the explanations for how household debt levels rose to unprecedented degrees in the decades leading up to the crisis was that this coincided with the withdrawal of the state. And so a lot of services which were traditionally provided by the state in terms of housing and education, well, instead now we borrow money to afford those. And also, I guess what Niamh mentioned earlier about taking the pressure off government in relation to investments, well, and saving for the future. It's similarly in terms of current expenditure in relation to people borrowing, where the state may otherwise have filled that role, and also just in terms of keeping economic growth going. If the state is not spending, well, we need to have demand in the economy, and sometimes that comes from consumers borrowing money. So just to bear in mind that if we're cutting down on state expenditure, we may be adding to the private sector debt, and there may be a day of reckoning to come in the private sector, and that's something that we might also bear in mind as well. And I mean, we see household debt levels are right on track to surpass the pre-crisis levels within the next couple of years, and we see that mortgage debt is going through the roof. At the lower level, we had a big outbreak of payday lending debt, when after the crisis, when austerity policy started to bite. So just we need to, I think it's useful to keep that relationship in mind also.
Thank you, Joe. Yes.
I'm Mary Stokes, and I'm a visiting professor here, but actually my day job is as a barrister in Erskine Chambers. And I guess maybe that slightly informs my question, that we've been interested so far in thinking about how far the law in relation to markets has some kind of redistributive function. And I guess where I'm coming from, we don't notice much of that at all. And I would say that where I see pressure points for the law and financial regulation, two issues in the recent past, and Eva has certainly touched on one of them, which is its modernity, its computerization. So I've been doing something today about crowdfunding, which, as you know, it's a way in which you use an internet portal to put investors together with issuers of either debt or equity, or it could be peer-to-peer lending. And the regulators are scurrying to catch up with it, and I'm sitting in Erskine Chambers devising ways which the client doesn't want to go through the regulatory hoops and is looking for ways round them. And the regulators are behind on it because they don't really understand the internet and what people can do on it, and the young men who come in are very savvy and they understand it. The second force I think I've seen recently is globalization, and it picks up again, I think, with something which Eva has been interested in. So it's the technical problems which are thrown up. For example, when a company which has got shares listed here in London also wants to list them in New York. Well, it does that through a mechanism called American Depository Receipts, but it is exactly what Eva has talked about, that we don't have an ordinary shareholder on the register. We have someone with whom the shares have been deposited, and then they issue things called depository receipts, which are bits of paper reflecting the beneficial rights in those shares. And, a technical problem came up last week. In fact, it came up on the Frankfurt Stock Exchange, but it could have come up on New York. How does the company buy back its shares? Well, these are not shares, these are interest in shares. And the law is very behind on that. Although I did notice when I was using my often used source of research on modern problems, which the books say nothing about, which is Google, Ryanair has been buying back ADRs, American Depository Receipts, in New York. How come it's done that? Well, actually, if you go and look at the Irish Companies Act, they allow you to buy back these creatures. And one wonders whether that's some sort of, Ryanair is obviously an important company. I don't know how they've managed to get that legislation on the book. So really the larger question with those two examples is a lot of what we're doing as lawyers maybe just trying to make things work a bit better, how they should work, protecting people, but allowing a market to function as it should when you bump up against new problems, computerization, globalization.
Right. Well, computerization must be an issue in criminal law. It must be a nightmare for forensic accountants and evidentiary.
Absolutely. I think everything you've said, I recognize. Your points are so well taken. I think you're absolutely right. And if you've spent your day doing something like that, I must tell you, on the other side of the fence, I've spent my day mired in the money laundering law in France, and looking at how that fits with the money laundering law in London, and trying to advise a particular institution as to how they can, I won't say dodge, but how they can make sure that they do fall through the gap, although that's perhaps a little bit unkind. I just recognize everything you're saying. I think the only solution is actually to recognize that the world has changed, and the world's got smaller, and we do have these international issues, these cross-border issues, and I rather think the only way we can deal with it is actually to increase international cooperation and to harmonize as much as we can. I think that's true in relation to the issues, for example, crowdfunding that you've raised, and also the issues that I've come across. I think that, truthfully, is the only way forward, which is one of the reasons, just to be thoroughly political, why, from my perspective, if you spend your time working in this regulatory environment and looking at the criminal enforcement of it, I have to tell you, the EU debate seems frankly very sterile. We need to be very much part of that because we have to go along an international route. I don't think we have any choice. Otherwise, we are not going to be able to deal with the problems you have so accurately, in my view, articulated. Thank you.
Thank you, Jonathan. The global versus domestic issue, I think, is very important as well. It seems to me that it must be important in insolvency law as well. Insolvency surely is governed domestically primarily, right? So a lot of the problems that may be created on the transnational or global level are filtered through insolvency laws. So the people who are at the receiving end of that injustice are the weaker parties in this whole process, right?
Yeah, it's quite interesting that insolvency law is very much within domestic lines, at least in the kind of household, personal insolvency sphere. I mean, after the crisis, there were some high-profile instances of cross-border insolvency within the European Union, particularly because in Ireland we had what was considered to be quite a draconian bankruptcy law, so there were a lot of high-profile stars of the Celtic Tiger years who were trying to seek to go bankrupt in England or Northern Ireland in order to avail of what was seen as being a more favourable regime. So we developed some bankruptcy tourism. But of course you're talking there about the high-end debtor, and these were the people who could afford the resources to move countries and to be well advised and to be able to play on this arbitrage between different jurisdictions. At the other end, I guess, again, taking Ireland as the example, you know, the global and the international very much influenced the experience of the law for ordinary Irish households who were trapped in debt difficulty after the crisis. And I guess one of the ways that manifested was as part of Ireland's financial assistance package, the laws were changed, but under the oversight of the European Commission and the IMF and the ECB, the Troika. And we see that there are various different interests at stake in terms of the passage of the legislation and in terms of the protection of various different interests within and outside of Ireland. And of course, yes, all of those international political fights are fought out, whereas the impact on the household debtor can be quite severe, I guess, when all these giants are pursuing their own interests. Yes. And I think that was manifested in the legislation which was passed, which was quite conservative and didn't really get to grips with the household debt crisis that we had in Ireland.
Eva, would you like to say anything to
Yes,
these
no,
points?
I agree that computerization and globalization are a combination that have thrown up a lot of problems. And I would also like to add that sometimes regulation can be the problem. So in my area, what has happened and has increased, it's hard to prove that empirically because I've been trying to find ways of finding data, but I can tell you that custody business has become a lot more attractive as a result of regulation. And the reason is that collateral, that is securities, have been required by regulation for people to participate in exchanges, to participate in clearing and settlement systems. So the regulator has sort of put up requirements to deposit securities as collateral. And that has meant that a market has developed of borrowing securities. So you can either buy the securities you post as collateral or you borrow them from someone for a period of time to satisfy your regulatory requirements. And that has created a market in securities lending. And that market is run or is facilitated by custodians. So custodians are able to generate revenue by facilitating lending. And that is quite a good business for them. And that has meant that the custody industry has become a lot more attractive. But of course you cannot generate more securities. So what has happened is, and the regulators sort of catching up, that custodians ask permission to lend securities. But they ask permission from their immediate clients. So if you have somebody somewhere in that level, their client will be another custodian. And that client will give permission. And at some point, you then need the permission from the retail investor. And they may or may not give permission. But the problem is the decision of the retail investor needs to be communicated really all the way down to the last custodian in the chain. And sometimes, and the more custodians there are, the longer the chain, the more borders there are in between, that information sometimes gets lost. And so this is an unintended consequence of an increased regulatory requirement for collateral that has all of a sudden thrown a frenzy into the custody industry. And I spoke to banks here in London who said, somebody told me, we deeply regret having sold our custody arm 10 years ago because it was an unprofitable, boring business. It's no longer that. It's a very profitable business, but sadly we got rid of it at the wrong time. It's hard to, nobody who thought collateral requirements were a good idea would have thought that this would happen. But yeah, I mean, it's an interesting, insight into the legal profession to say our role is to make things a little bit better, but maybe that's all we can do.
Yes, absolutely. Great point, Mary, about the crowdfunding thing. So I always have mixed views on crowdfunding because it is it's one of those classic issues the regulators are getting terribly excited about, and an awful lot of policy work and consultations, and it's crept up into the international space for standard setting. And ultimately, in terms of the risk that's being addressed, there is a kind of a question. So if you look at, I'm a company issuing 5 million worth of shares. So under traditional law, I don't come into any of the normal rules about selling my shares because it's under 5 million. And the law kind of set up that exemption because, well, look, that's a small number of people. That's maybe, 200 people, 500 people. It's not a lot of people. Now, they could all get badly burned if something goes wrong, but it's a small number. So the trouble with crowdfunding is you have your 5 million, so you're sitting outside the rules on raising funding, but you can reach an immense amount of people through your website with the 5 million. So sort of the detriment is the same, but it's now a scale issue So you can see regulators kind of struggling with, the risk really isn't any different. It's just it's reaching a lot of people. So I think regulators are kind of recalibrating, how much damage are we kind of prepared to tolerate. So I think you're absolutely right that it's a key issue. The second issue I think computerization brings up is which lever are you pulling? And I think regulators are trying to think their way around this. So for example, if you look at automated financial advice. So a lot of investment firms are setting up these sort of computer programs. Do you have X funds? Are you in work? What's your risk appetite? And they kind of, it's like a computer program. You trick your way down and buy shares or buy whatever, but it's a kind of a decision tree. And traditionally that have been regulated as a sort of it's investment advice. But of course a good lawyer will argue very easily, no, that's not investment advice. Where is the relationship? Where was the contact point? Did they assess you? No. Regulation doesn't apply. Whereas probably the right lever to pull is product regulation. You've developed a product which is an automated advice product, and then that allows you to pull another lever in terms of controlling the firm. So I think it's forcing regulators to think about why they're regulating, which lever to pull. And of course, it's not obvious they're doing this nimbly or in any kind of, imaginative way. So it is a huge challenge, absolutely.
Yes, the gentleman in the back.
I have a public health position in researching how wealth inequality influences health. So I'm sorry if I'm slightly naive, and perhaps this is out of the box a little. But I have been curious for a while when I look at wealth issues. So this is slightly more political than law. But if I'm not mistaken, capital gains tax is taxed at a lower rate than income tax. Am I wrong there? Sorry. If that is true, then I've not heard a convincing...
well, I'm pretty good on evasion rather than actually planning. But I don't... I think capital gains tax is still taxed at a lower rate than the highest rate of income tax. If that's what you were asking, the answer is yes.
So, given that's what we know, I've not heard a good reason of why that is the state that we've upheld for a while now, and I've not heard enough challenge to that state of affairs. And what is the rationale? Why should capital gains be taxed at a lower rate than income? What is the simple answer to that kind of...
Well, I don't know, and I've got no inside track with the Treasury. My guess is that it's something to do with encouraging people to invest and make profits and be terribly capitalistic, I would imagine. But of course, it's right to say that there are some around who would like to see the income tax rate lowered. So it does become rather political. But I really can't say any more than that because I'm going above my pay grade.
Well, one of the themes that has emerged so far is that there is certainly an inequality in the way different parties in the market are being treated. Right? So it seems like the weaker parties are treated more harshly for a variety of reasons. Some of those reasons are systemic. They have to do with, for example, the use of contract law, which is all about the will of the parties. And of course, relative bargaining power comes into play. Other reasons are, it seems to be, structural. So, again, the tension between the domestic and the transnational or global comes into play. So, to put it very roughly, to the extent that I understand it as well as an ignoramus legal philosopher, it's a lot easier for a big corporation to hide through really complex global systems of debt and equity than it is for a poor fellow who missed his repayments and is losing his property. So I mean I don't know whether this asymmetry of between capital gains tax and personal tax might fall under the same. Well, it falls under the same pattern. I'm not sure whether the reasons are quite the same. But speaking of all that, and speaking of asymmetries, I want to come back to what Aoife said earlier, but quickly dismissed it. But you weren't justified to dismiss it. That it's just simply too difficult, and lawyers, some lawyers are better than others and they're more expensive than others. So these things matter a lot. So what I wanted to ask is whether regulators and lawmakers are under pressures, real pressures by stakeholders in that whole process, and whether that actually does make a difference, and whether it makes a difference, if you like, in domestic jurisdictions than it does in transnational context. So, to put it, very simply, is there some sort of suspect intimacy between regulators, or lawmakers, and powerful stakeholders?
Well, so in my area, the problem is that whenever, for example, the European Union consults, and you look through the responses that are published on their website, you find that the very big players have written very polished responses. So they are able to articulate their concerns and express themselves in terms of serving the market. You very, very rarely find people responding from the investment community. You get an occasional response from a shareholders association. Sometimes a trade union says something. So I don't think there's a conspiracy, but it is certainly the case that the very big players have the means to pay people to respond to government consultations. And also, so when I published this paper that I'm sort of talking about today, I published it on a system called SSRN, Social Science Research Network. Within a week, I had 2 phone calls from lawyers working for a very large custodian, and they just wanted to talk to me about thesis, and they didn't want to influence me in any way. They were just interested in the argument. And so that custodian has the means to pay somebody in their legal area to screen SSRN, to screen what is published, and to sort of anticipate what's coming their way, and to sort of find ways of reacting to those arguments. And that is a level of sophistication that's very, very difficult to beat.
Quiet. Yes, please.
Can I say this? Really, it's 2 aspects. I agree entirely. I recognise what you're saying. On the sort of the macro issue between the relationship between stakeholders and regulators, well, I must tell you, I've been troubled for a very long while about the relationship between the FSA or FCA and those that it regulates, just by virtue of the funding arrangement. I mean, as I understand it, essentially, the regulator is being funded by those it regulates. Now, I know in professional circumstances, of course, that's true of professional bodies, but it just seems particularly unhappy when we're looking at the regulation of the financial markets, when the FCA, the regulator, has the power to bring criminal prosecutions and is not actually, as a matter of law, under the superintendence of the Attorney General. And I do think that raises various issues about the way in which we have set up structurally the architecture of financial regulation. Now, I know the argument, which is, well, if you want it to be a government department, perhaps you'll kindly pay for it. Well, okay, up to a point, but I'm sure we can do it rather differently, because it just seems an unhappy arrangement that we carry on with, and nobody seems to challenge. And actually, I think it's about time somebody put a stake in the ground and said, well, actually, this really is not the best way of doing it. As for you, for the paper you published, I have to say it does remind me a little bit. I've been in a similar situation, nothing as grandiose as publishing a proper paper, but where I've said something, and it's usually been in terms of the corporate criminal context, and you say it's really, we must expand the liability of the banks, and I will get calls from firms of solicitors, mates of mine who are working in the field, who are actually acting on behalf of banks, and they are phoning to say, are you serious? Do you really mean this? You do, and the veiled threat, well, nobody will actually say it in terms, is, well, if you really are going to go down this road, you're not going to endear yourself to the banks. And that certainly is going on. The fact is there are people who are retained in the large Magic Circle firms who take it upon themselves to adopt the persona. I don't want to be unkind, and I certainly wouldn't finger anybody in particular, but in reality, you stand back and you think, you know, actually you're almost at the point where you're adopting the persona of your client, and that's something really and truly we should be careful about.
Yeah, I very much agree with this. I think in the consumer space, it's actually quite insidious. It's quite subtle, I think, what the problem is, because I think it's Ian Ramsey has this great phrase about, you know, you can't get together. It's very difficult to get consumers of financial products politically active and politically engaged. They're too diffuse. They have different interests. They literally go from Joe's kind of excluded person to my person who's trying to kind of save for their pensions. So how do you organise them? So inevitably, their interests have to be channeled through the regulator. Every so often, you'll get this, and this is Ian Ramsey's phrase, the panicked mass public. So that's October 2008, this overwhelming sense of this cannot go on. But that's happening every 25 years or so. So you have to depend on the regulator identifying and articulating and responding to a consumer interest. And I think a lot of them will do that, and they'll do that seriously. Where it becomes insidious is this: there's no challenge. So has the regulator identified the investor? Do they know what the issues are? Is there a groupthink going on? So they can't, it's very difficult for them to engage with the consumer stakeholder. And then the second difficulty is you have this squeezing out dynamic. So you have highly accomplished, highly technical, highly competent market organisations driving the agenda. So if you look at the new thinking in financial regulation since 2008, it is almost entirely in the wholesale market space. And that's where the energy, the creativity, the policy energy, the resources, the political energy, that's where it's been. And it's because of the nature of the policy community. There's been very little new thinking in the consumer space. Not because it's not valuable, it's extraordinarily important, but you don't have that sense of a very informed stakeholder community driving developments. So I think it's not so much that consumer interests don't get addressed or their legislation is changed because it's too costly. It just doesn't develop. And that's, I think, a more insidious risk than actual, legislation being cut out or changed or watered down.
Thank you.
Yes, I would echo those comments. Really, I think, I've looked at the problem of legislative capture a little bit. In my field, it's often given as an explanation for how we end up with a bankruptcy law. For some of the reasons that Niamh and Ian Ramsey mentioned, we have, on one side of the argument, we have a very united small group in the financial sector who have more or less similar interests in what they'll be arguing for. And on the other side, we have all the consumers who might want various different things. And how do we organize a group like that? So if it comes down to pushing the law in a more financial sector friendly or a more consumer friendly direction, well then there's only going to be one winner in that contest. Now, after the crisis, people thought, well, things might be different. We looked at areas like financial regulation, like bankruptcy, which were traditionally seen as low salience issues. You're not going to win an election based on financial regulation, right? It's too boring, that kind of thing. But then there was, these issues suddenly became very salient, and we saw the public paying a lot of attention, and then legislators started getting a little bit more worried. But it seems that ultimate outcomes, from my experience and my research, particularly in the developments in Ireland after the crisis, was that this only got so far. And if I've tracked the history of the development of the Irish bankruptcy law, and what I noticed was that when certain stages of the legislative process took place in public, where all the debates were published and where politicians knew they were in view and knew that their voters would see them in view, they were pushing the legislation very much towards a more debtor-friendly, household-friendly model. But then the legislative process moved back to, the cabinet offices and government departments, and the final draft of the and meetings with the Troika in this case, and the final drafts of the legislation were very much pushing in the other direction. So I guess what that might teach us is that they're in these kind of quiet areas of quiet politics, perhaps there's greater scope for sectoral interests to have influence, and maybe in the more public spheres we can have more popular interest taking effect. So I guess what that might suggest is more transparency would also help in terms of how we talk about these issues and how we make our laws, as well as how we apply them.
Right, we've almost run out of time. So do you have any closing remarks? No? Well, you don't have to.
I haven't really thought of anything that would be terribly coherent.
Well, I mean, I do. No, I mean, the only thing I wanted to say is that I still find very interesting and quite disturbing at the same time the idea of financial citizenship, which is, it might just be rhetoric for now, and it might just be employed in the retail investment area, but I think that there is a pattern emerging that membership of the community now is participation in the market. But of course, that's not membership of anything at all. I mean, this is just antagonism with others. There's nothing to be membered to in that sense. So I do find that quite disturbing. Right. Of course, we didn't cover the whole relationship between law and wealth. We didn't see the very big picture. Not least because I think that's probably impossible. What is possible to do, especially in such a complex world, which is regulated by law and is meant to reproduce and distribute wealth, what is possible to do is look at snippets, just some fragments of the big picture. And we saw snippets of fantastic research being done here at the LSE Law Department, by Joe Spooner, Aoife Michele, Niamh Moloney, and Jonathan Fisher. So thank you all very much for being here, and thank you to our speakers.